Welcome to the lesson on gross negligence manslaughter. As usual, the learning materials for this topic can be found in the description below the video, in order of appearance. Gross negligence manslaughter is shaped heavily by a line of leading authorities, beginning with the conjoined appeals in Prentice, Holloway, and Adomako. Before these decisions, the courts had attempted to align gross negligence manslaughter with the older test for causing death by reckless driving. The Court of Appeal, however, was unwilling to continue down that path. It held that the reasoning in Seymour applied only to motoring fatalities, and that, for all other forms of manslaughter based on negligence, the appropriate approach remained a distinct test of gross negligence. When the issue reached the House of Lords in Adomako, the conflict was resolved by articulating a clear and coherent framework. Their lordships confirmed that liability requires three elements. First, the defendant must have breached a duty of care owed under ordinary principles of negligence. Second, that breach must have caused the victim's death. And third, the negligence must be so serious in the view of the jury as to amount to gross negligence. Crucially, this misconduct may arise from an act or an omission. Turning to the duty of care, the traditional categories such as doctor-patient relationships are straightforward, but offer little assistance in the context of criminal cases. In practice, the courts often locate duties of care in situations involving hazardous activities. One illustration is Ruffell, where the deceased had taken heroin with the defendant and was left outside overnight, eventually dying of hypothermia. The hazardous activity they had jointly undertaken created a duty of care, which the defendant subsequently breached by failing to safeguard the victim. A significant development occurred in Evans, where a young woman died after self-injecting heroin supplied by her half-sister. The defendant recognized signs of overdose, but together with her mother, avoided seeking medical help due to fear of legal repercussions. The Court of Appeal held that the act of supplying heroin was itself sufficient to establish a duty of care. Notably, it was not the family relationship, but the creation of a dangerous situation, providing a Class A drug to a vulnerable user, that grounded the duty. The courts reaffirmed this approach in the more recent case of Phillips. There, an experienced heroin user had taken the drug with a novice. Although both individuals had purchased and injected the heroin independently, the defendant was familiar with the symptoms of overdose and saw that the victim was in distress, yet he failed to obtain assistance. The court held that the defendant owed a duty because he had participated in supplying the drug and later ignored clear indications that the victim's life was in danger. The fact that the defendant had not personally administered the heroin was irrelevant. Moreover, the seriousness attributed to such cases is reflected in the substantial sentence imposed in Phillips, which signals the gravity with which the courts treat this form of manslaughter. However, establishing a breach requires proof that a reasonably prudent person would have foreseen a serious and obvious risk of death, not merely injury, including serious injury. Leigh and others have criticized this stringent requirement, but without success. The courts maintain that the criminal law should impose liability only where the danger is one of death, rather than lesser harm. In recent years, the prosecuting authorities have increasingly pursued prosecutions in business and institutional settings where a serious safety failure caused death and a reasonably foreseeable risk of death was ignored. For example, in 2025, the investigation into the senior leadership at the neonatal unit, where Nurse Letby worked, was expanded to include G&M charges against individuals, as well as corporate manslaughter. Regulatory bodies have also stressed that individuals may face prosecution if they ignore life-threatening safety risks in workplaces or care environments. These trends do not change the legal test, but they illustrate how the offense is increasingly applied to situations where grossly negligent omissions by individuals can have fatal consequences. This shift reflects the message that individuals at senior levels can face criminal liability, where grossly negligent omissions lead to death. Thank you for your interest in this topic. We hope that this lesson was helpful to you and are looking forward to seeing you again soon.